ask me, the person who actually teaches you the law is the judge sitting on that other side. That person, and if you want to learn the procedure, the person sitting in the registry will teach you the procedure. So these two people are actually the gurus.
Hello and welcome to the Superlawyer YouTube channel. Today we are back with another engaging conversation. We are with Ms. Mayuri Raghuvanshi. Ma'am is an advocate on record at the Supreme Court of India and is a seasoned legal professional with over 18 years of experience in diverse fields, which include constitutional law, environment law, ADR, and other fields as well. She serves as a senior panel counsel for several prestigious organizations and also an honorary faculty at the Symbiosis Law School, Noida, and ISTM. Ma'am is an active contributor to the legal education while being involved in legal reforms, gender sensitization, and judicial training initiatives. We welcome you, ma'am, today. I am Anshi, and I am an associate with the Super Lawyers team. We at Super Lawyers aim to showcase inspiring stories that could motivate and benefit our readers, which are young lawyers and the legal community at large. I'd like to introduce you to Divya ma'am now. Divya ma'am is our team lead at Super Lawyer, and ma'am has extensive expertise in legal and technology matters, including AI, ethics, privacy compliance, IPR technology, and other related areas. She is also a practicing advocate of the Supreme Court of India and offers valuable insights in complex legal and technological issues. Thank you so much, ma'am, for joining us today. I request Divya ma'am to please now take the dais. Thank you so much.
Thank you for having me. It's an honor.
You and she for bringing ma'am to our platform. Thank you, ma'am, for bringing in such insights just before the interview. And welcome, ma'am, and thank you for carving out time for our interview at Super Lawyer. I'll immediately start with the question which was there in my mind to ask about the story behind you choosing law as a career, and what kind of moments would you like to share or experiences that have motivated you to go on and on for almost 2 decades now.
Well, I think simply because one life is not enough for law. You know, every day passes by and you have learned something new. There will not be a single day in this profession where you will not go to bed with a feeling that you have learned something new today. And yet, when you try to ask yourself, do I really know the subject? The answer will definitely be no, because it's vast, is huge, and it is dynamic. For example, several of the subjects, I think you would have also felt the same way, that we practice today, we had not studied in law college. So they are new to us. We learn every day. And the profession, I mean, now, of course, there are various aspects. Once you have your law degree, there are various ways in which you can put your legal education to use. But even if just talking about litigation alone, every day you will learn something new. I have been doing this for almost a 2 decade, as you rightly pointed this out. But there are so many areas of law which are new to me, and I'm still looking for an opportunity to learn and grab that. So I think that's the romance of law. That's the whole idea, the fun of being a lawyer, that you learn every day. I mean, look at it like this. Suppose, I was in a different profession. Perhaps you would have called me a middle aged woman, but I'm a toddler in the profession still, young. We have a very long professional life, so which keeps us young and alive. And that's the beauty of the profession. That's why it's all worth it.
Well, now we have to go back to the story why you chose to do law.
When we were in school, the usual thing was that if you're a good student, you would study science. So I also wanted to believe that I was a good student. So I took maths with biology as a subject in class 12, with clearly shows that I was confused and not very clear about what I wanted to do. But yes, everybody said we have to now sit for the competitive exam. I had, though, had one advantage. My parents have studied law. And I think my father, I have in that sense inherited my father's passion for law, for the subject. So I remember my evenings were earmarked for me with my father. And once, where I think what sparked the interest was when I was in class seventh or sixth, my father was reading Lord Denning's closing chapter. And he would come back, and I still have a very vivid memory that the time he would spend with me asking me what I was doing, he would sit on the corner of a sofa and just sit with a book and Perhaps he was so engrossed in reading it. And I thought, who is this bald man who is eaten up on my time? I want to know who this bald man is, not knowing that who actually Lord Denning was. And that's where I started actually going through his books and all. So very often it happens that we are interested in or we choose a field because we have a role model and where we want to become something. We want to become a lawyer, so we want to study law. In my case, it was the other way around. I was so confused that what I want to study, what do I really enjoy reading? Today, I am able to articulate it, but when I was a young girl, I had a difficulty in articulating or understanding my own interest. So while I was interested in stories, interested in history, interested in all sorts of books that were around me, and certainly, when I was looking at even as the science subjects like maths, physics, chemistry, biology, the ones that I was reading to score a mark, it was more out of a curious interest. My hobby or the time when I had to recreate or my leisure was all filled with all kinds of books. My father once pointed out to me that, look here, this is your bent of mind. This is what you should look at making your profession. So I would write poems, I would read poems, I would do things, but I was really never able to understand it. And as I was telling you, that I did clear an engineering entrance exam, and a day before I cleared, and interestingly, when we were in school, the whole quest about getting to a law college, there weren't so many law colleges then. And my father is the old world person in that sense of the term, that he believes that if you want to study law, you should have certain maturity. He says that you can't teach fundamental right to a 17-year-old boy. That's how he looked at it. So when I first started expressing myself that I want to study law, my father was of the view that I should do a graduation program, any subject that I want to study, and then take up a 3-year law course. Because he still, I mean, and this is something I can now understand. He said, how can a 16-year-old person understand or 17-year-old child understand jurisprudence or what is a fundamental right? And he would all the time tell me, he said, to understand right to life, you have to live a life. There were some 5-year law colleges which have come up. So I finally managed to convince my father that allow me to sit for an entrance exam. Or us samay mein, if I can recollect correctly, there was National Law School, Bangalore, which I could not appear because by the time I could convince my father that I really want to write this paper, the dates had closed because I was standing in February by that time. So the only entrance exam I took was symbiosis. And in those days, there was only one symbiosis, which was in Pune and affiliated to Pune University. It was still not a deemed university then. And I remember I had my entrance exam in Teen Murti Bhavan, and I enjoyed my entrance exam like anything. I knew the answers at the back of the hand. See, maths, physics, those legal deductions, when you were studying maths in class 12, those were like baby steps. It wasn't difficult at all. General knowledge, I realized that that's where I really understood that I knew almost everything. For example, there was this question, what does parliament consist of? So I knew that it was Rajya Sabha, Lok Sabha, and the president. There were questions pertaining to legal news and the current affairs, and I knew all of that back. And I remember my name when it came in this, I was at serial number 8 in the list. So when I went to my father actually, and I said, let's go for this. And that's where my mentor, Dr. Klein Pandey, he also played a very important role in finally deciding because all said and done, even in those days, somebody would call you a fool to give up engineering and study law. But I was glad that I was surrounded by these people who were passionate for law. So they were able to put me to that thing and actually tell me that how beautiful this subject was. And once I was in the college, I remember after the first class, I went back and I called up my father and I said, I finally know what I'm going to study for rest of my life. My soul has found the place. So for me, it was more about the passion for law. So even today, while I am a lawyer, I practice law in court, it's not about what I want to become. It's always the subject is the core thing, which is at the center of everything that I do. So it's the love for the subject which takes precedence over everything else. A subject that I don't know very well.
Ma'am, after all this, such inspirational stories, and you remember date, you remember the sequence, you remember even the question that you gave in your entrance exam. Amazing memory, ma'am.
I enjoyed it actually. There are two exams that I enjoyed thoroughly. One was my law entrance, and the other one was my advocate on record exam. Even if a bomb would have dropped outside, I would have cared less. I would have perhaps continued participating in the process.
And that shows your love for law itself, the way you are passionate about it. I really don't have words. It's just your sheer love and passion. And I guess really your soul found the true calling and the way you wanted to go. I guess everything was carved since childhood, as your parents, both of them were lawyers and they were law graduates, and the way they have nurtured you. Amazing, amazing. And we found an advocate on record because of that. Amazing. There have been times in the very start of your career, you had that option of joining the esteemed advocates like Advocate Gopal Subramaniam, sir. How did that experience shape your approach towards law or the practice of law and the kind of research that you may have done at that time? What kind of learning do you take out from there and you have applied that in your obviously the practice henceforth?
The most important thing in a lawyer's life is the chamber a lawyer starts from. I had been exceptionally blessed because the people I worked with, and particularly the initial years where you spend, see, it's like in our profession, we say that the horse is from which stable? That's your genealogy. That's your pedigree with which you go. So I am very lucky that way because that's what shapes you. It's one on the face of it, it may look that they have just taught us, we have assisted them. But it's like a relationship between a senior and a junior is very much like a parent and child. And that is because when you're a baby, you hate everything that your parents say. You disagree with them. You say you don't understand why they are doing something. You sometimes find them irrational. But as you grow up, you start realizing why they behaved the same way. And to your nightmare, you will realize that you have also turned them. So, in a way, there are some things, like, for example, since you mentioned Sir's name, so Mr. Subramaniam's chamber, I can bet you go to any junior who has come from that office, you will see we all have a style of preparing a note that we take to the court. Now, this is the note that we used to prepare for Sir. I still don't know how to read a file or go to a court without a note in my hand. Now, of course, my notes have shifted to the electronic notes. But even today, while I use liquid text and which has all the features that you can interlink and write just the way you could scribble it on a paper book, I still make my note. All my files have a note. So it's a very typical thing. And you will find that I can bet any junior today from Mr. Subramaniam's chamber who will not have a note in his file. We don't know how to read our files without the note. So it's like I've just said, this is one thing that we all have imbibed. So we all imbibe certain traits, the way we work, the way we think. Like Mr. Subramaniam was an early riser. He would start early in the morning. Now, most offices work late in the night. I have by default become an early morning person. I can start early because he would work that way. So we got sort of acclimatized to the way he worked. So those things you may not realize. Like I didn't realize it for a very long time that this is what was happening. But now that I sit back and reflect, sometimes I think, I'm always more comfortable starting early rather than doing something late at night. I would like to read my files, revise my files early in the morning again, or have a conference, have a meeting with the clients early in the morning rather than late at night. So it is more to do with the fact that how you, so it defines almost everything. And it is not just the people that you work with. Like for us, we have also have the benefit of some of the stalwarts who are there in the profession, and then we assist them. So every time we assist them, there is something that you learn from them, you by just observing them, watching them. And actually, if you ask me, the person who actually teaches you the law is the judge sitting on that other side. That person, and if you want to learn the procedure, the person sitting in the registry will teach you the procedure. So these two people are actually the gurus that we have in that sense of the term, because we learn while we are interacting with them. So they are the best gurus, actually. The judges are the best teachers in that sense.
Ma'am, you practically take out all that guru factor from everywhere you go, from registry to judges to
Yes.
even your juniors, your seniors, everyone. That I really feel like that this should be the way to learn from everyone and whatever possible. Everyone has something good to give you. And somehow I guess you have done that, and that has become your way of working also. Ma'am, all of this kind of working is not found everywhere and with everyone. Obviously, everyone has
Yeah.
their own style. How did you choose your style, and when did you decide to start your own practice? Kind of motivation that was behind all of it? Because it's not always easy, I would say, a
Mm.
decision to go independent and start a
Yes.
whole firm for themselves. When and how you decided it?
So there wasn't a moment that when I decided. So I started working, and at my first chamber was a chamber of an advocate on record. So I had one benefit that I was very clear in my head that if I have to practice in Supreme Court, I knew what an advocate on record was. I knew that it would take me 5 years, which effectively becomes 6 years, because our results in Pune University were declared in the month of June. So by the time we got our certificates and other things, our enrollment happened in July. So the AOR rule is that after 4 years of your enrollment, you then have to undergo a 1 year training with an AOR, and then you would take. So effectively, what is 4 plus 1 in my case, because the notifications comes in the month of April. So those of us who have got enrolled post April, just like any other nursery admission that happened for a child, if you're born in June or in July, you will have to wait a year more. The same thing happened. So for me, it became a 6 plus thing. I started preparing for my advocate on record thing. I was very clear that if I have to be here, I have to be an advocate on record, and I have to clear this exam. And I started with an advocate on record. Then I got an opportunity to work with Mr. Subramaniam. Now, the advocate on record, now he is a designated senior, Mr. Bhatt. He was practicing only in Supreme Court. His work was only in Supreme Court. So, which meant that my initial years with him, the entire exposure was only Supreme Court and no other forum. And when I was thereafter with Mr. Subramaniam, so although he had a very vast, like if somebody will today work in his office, he will have various experience. But when I was with him, he was Solicitor General. So, which also meant that he was also extensively doing only Supreme Court work. He really didn't have time. And those were pre COVID days. So, there were no online appearances and other things. So, he was stationed in Supreme Court. I hardly remember assisting him in one or two matters in High Court. Otherwise, we were just in Supreme Court. And so, I was with him during that period when he was Solicitor General. As a result, what I realized by 2009, when I was already like 3 plus in the profession, that I have no experience of original side work. I was absolutely blank with trial court, with high court, because the only forum where I have effectively practiced. So, one benefit, of course, you have if you are in Delhi, that all the tribunals, all the courts, like if you are in any other district, you will have one trial court, one district court there. You may have a high court, you may not have a high court also. But we have a high court, we have 6, 7 district courts, we have tribunals. So it's like a makkah of learning litigation. You can learn anything that you want under the sun so far as litigation is concerned, any field of law. So I did had that benefit. So I could, see what a consumer court was, argue one of matters in NCDRC, but I had no experience of conducting an original site work. And if you still ask me, that is one area that fascinates me so much. So I was so desperate to learn that I started taking up work from different people, started assisting wherever I had the opportunity to do up a trial court work, to draft a plaint, which I had never done. And Mr. Sanjay Ghosh came like an angel in that point of time, who had a reasonable practice in the High Court. So then I got my first hand exposure for the High Court, how it works. And High Court Delhi also has original site work, just like a trial court. So we got that. I really got the exposure to original site work then. Then I started learning that you can actually learn from anywhere. So if somebody wanted to ask me, if I saw an arbitration proceedings going on, I would volunteer that can I assist. in this arbitration proceeding. And I started marking my calendars, maintaining my diary as if it was my own matters. So I would mark them when there was another date, I would mark them, follow them religiously. So literally in my head, even though I had no client, no money, I was not raising any bill, but in my head, they were my matters. So I had got that sense of belonging that, oh, these are all my cases now. And I didn't even realize when the clients actually started coming in, one small matter, one small there. But yes, by the time I became an AOR, I had few matters here and there. But then my career, in that sense, in real commercial terms, really didn't take off. That took off once I cleared the advocate on record exam. And as a result, one of the biggest benefits which I got was this, that, and that's one thing whenever people say that if you're a first generation lawyer and they say we don't want to become a AOR, it's very clerical. I often tell them it gives you one big liberty, which is this, that you can do a matter for free in Supreme Court without being dependent on anyone. If you're not an AOR, you'll have to engage an AOR. As an AOR, if a client comes to me and say, I can't pay for this matter, but would you still take it? I can still do that because I don't have to engage any other lawyer. I can draft, I can file, I can argue, I can do everything. And also, you can become a commercially viable lawyer in the sense that if you're able to do good work for a lesser amount of money, you will then be able to attract that kind of clientele around you. You will not be dependent for the matters for somebody to actually pay you for you to have an opportunity to work. You can create your own opportunities. So it was a very gradual process. But once I became an AOR, by and by, I started realizing that I could get on with. So this was a trick I learned from an interview for Zia Modi. So Zia Modi, in one of her interviews, she said that her boss, her mentor, told her that what is that one thing you can do, which you can offer that no one else can, because she was talking in the context of being a woman. And she said, oh, I'm a woman. She had come from America. And so she felt that there were no clients. She said, nobody is sending me brief. And in Bombay, no one is engaging me. So her mentor, he advised her two things. One, that you start wearing an Indian dress, which of course it's something that you may or not follow. It's up to you. I don't subscribe to that part of the story. The second part he said was that what is that one thing you can offer better than the others? So, of course, the others are more experienced. He said, but you can do the work for free. Nobody is working for free. So, start working for free and then make your own place there. I have followed that. Keeping your prices very low will give you opportunities, and over a span of time, it all equalize. So, your work will not stop for lack of money.
Ma'am, but there are times when people question this aspect also, that if you keep on doing things for free, when will you do it for yourself? I'm just stating things that many a times it has been said. All of these challenges are there, similar for everyone else. How have you gone through all these kind of challenges? How have you strategized your practice? What kind of suggestions would you have for the new entrants or the people who want to make a mark for themselves? Because you have expertise in so many, so diverse areas like service laws, company laws, taxation, civil, constitutional law, anything and everything. And wherever we see you have done some or the other complex cases. How have you done that, keeping in mind that you can do things for free also, you can charge as well, but you have overcome that challenge? Because for people, for everyone, I would say, it becomes a little challenging.
One of the best thing is if you can not let an opportunity go by. An opportunity comes sometimes disguised. What may today appear to be a free thing, tomorrow may turn out to be something which you'll end up making a lot of money. Like, I'll give you an example. When in 2013 the Sexual Harassment Act was passed by the Parliament post Justice Verma committee, a lot of these organizations were struggling with how to form these sexual harassment committees. I had a couple of companies who were my client, who, like there were some PSUs where I was on the panel. And my friends would just call me up, the law officers and who were there, they would just call me up, ये committee कैसे बनेगी, ये external member कौन हो सकता है? And I remember by that time when my first query came, the rules had just been notified. So everybody was struggling. I remember, so just for free. I didn't let it go. I also sort of just opened up the Bear Act with them, sat with them, and we decided what could be done. Now, initially, it will look like that it was a complete waste of time. I was doing something for free. And everyone would turn around and say, oh, you could have charged for this opinion that you've just given. And believe me, I have, as any lawyer, would have also done that. I also do that now sometimes. That's how I earn my living, by billing for an opinion, by billing for a conference, by billing for a meeting, by billing for an appearance, by billing for a draft. That's how I earn. But I just went ahead and did that. And you will not believe that one led to the other, to then to the other. And when it translated into litigation, when it translated actually into billable work, it was like within a short span of time. So, one, I mean, don't let an opportunity go by thinking that at this moment you're not able to monetize it. You may not know that tomorrow you'll be able to monetize. That may become the starting point of another big opportunity that may land your way. The same happens with All India Judges Association. A lot of my work that I do is relating to service matters and matters relating to judges of the district judiciary. But All India Judges Association is my pro bono case. I have not charged them anything. As a matter of fact, I started working on the first matter when in 2014. And in 15, the matter came out. So it was a long journey, but one thing led to the other. And in that whole process, I have also learned. So the important thing is, please don't have a myopic view of the career. You're not an employee. That's the first and the foremost thing. If you've decided to be a lawyer, one of the things you have to understand is you can't apply standards that would be applied to an employee in any other place. And when I say this, please do not misunderstand me by saying that I'm asking people to work for free in a lawyer's office. No, I'm not asking you to work. I'm not saying that juniors should work for free or something of that sort. But you need to understand the basic understanding of the profession. It is a profession of personal service, which means when a person engages you to appear in a matter, it is with an understanding that you will go and argue the matter. The person comes to you for who you are. And every person has his own style of presenting a case, because at the end of the day, you have to present an argument. I may be comfortable in one way, some other lawyer may be comfortable in another way. So at the end of the day, it is sometimes a client's call. Who is that person he can trust, he or she can trust, or who is this person, how this person will present a case, what will click, what will not click, because each one of us, the same set of facts, one lawyer may present it in a different style, the other one would present it in a different. So it's a very individual thing. As a result, what happens is that the people who work with these lawyers, particularly if you're a senior counsel, then it's the juniors are there to assist and help, but they can't replace. Now, that's a very unique characteristic of this profession. If you were an engineer, so the assistant engineer could also operate the same machine in his absence. Now, that even like conducting a case, for a lawyer to hand over a case to a junior, it's something that the client has to agree. He has to be comfortable. It should not appear like a breach of a understanding. As a result of which, the employability, the role, it's unlike other profession where somebody is hired on a package basis to do a kind of a job, and in his absence somebody else would take on that job. That's not here. I often tell people, my students particularly, I said, this is like अमिताभ बच्चन की पिक्चर में अमिताभ बच्चन ही होता है, ठीक है? सो अगर अमिताभ बच्चन वो पिक्चर नहीं करेगा, शाहरुख खान करेगा, तो वो शाहरुख खान की पिक्चर हो जाएगी. So you can't therefore say ki, okay, I am assisting Amitabh Bachchan, so if he's not there, I can actually go on and take the shot on his behalf. It may not work. It may actually not work. So that's the difference. That is why, until and unless you understand and grasp this reality that you're not an employee, but you're an entrepreneur, you will have to develop your own clientele, develop your own thing. You will have to, if you're looking particularly to become an arguing counsel, then you have to be the hero who can carry the movie and have a box office success on your shoulder. Once you have understood this, then everything will become easier, because then you will not complain about the package. Then you're not looking at what have I done today, what is my punch in time, what is my time sheet, because then it is something which will not be uniform, which will flow, which will have its ups and downs. So then you have assimilated yourself in that system, then it becomes easier.
Wow, ma'am, everything is so clear about what and how you want to develop it or you have done it. Ma'am, you have also been involved in a lot of gender awareness things, especially being involved in internal complaint committee, which is under sexual harassment of women at workplace act and all. And you are also external member for organizations such as Rashtrapati Bhavan. What kind of challenges you face while you are addressing these kind of gender sensitization issues, where you have to talk about sexual harassment prevention and the kind of ways or the way one can help as an advocate and as being a human, you assist or help them in overcoming these issues, because all of this has become more common as much as women are coming out and working in whatever environment. So how have you addressed these things under your supervision?
There are two kind of things which I have done. As a matter of fact, when it comes to gender sensitization, see, it's really a subject I think we all are passionate about. And in fact, I'm currently pursuing a PhD, which is on feminist jurisprudence. So that's the area of my interest. And it has developed while working on all these issues. I have primarily had the opportunity of dealing with this law in three capacities. One is as a capacity in a lawyer where I have represented these clients in the court. Second is where I have had the opportunity of sitting in the committee as a member and actually adjudicating the whole complaints as per the act now. So, which meant I had the role of deciding those issues and had to really conduct the whole inquiry, which also helped me, by the way, in understanding the disciplinary inquiries generally that happen in. So I can now, when I read a file or when I argue a matter in Supreme Court, I find it easier to relate it to how it would have really happened behind the closed doors in a departmental inquiry. The third which I had was by conducting these awareness workshops, which I really love to do. And we have done that for various institutions. Every organization, every institution has its own problems, unique problems. But one thing, if I have to highlight what is the biggest challenge, is this, that as a country, on a jurisprudential term, if we just talk about the law, we are still not very clear on what is sexual harassment. For example, we had Vishakha in 97. Now, if you look at the 2013 Act and the definition of sexual harassment, it's more or less a repeat or a replication of what was envisaged by Justice Verma in Vishakha. We have actually taken that same thing forward. But the problem is that it's a bare bone skeleton. Now, for example, it uses the word that sexual harassment means any unwelcome advance or contact. Okay. Now, advance is a lot of things. In a virtual world, it could also mean a virtual advancement. Could be stalking, sending a WhatsApp message, asking for a request. I ask you for a cup of tea. You say no. I insist. You're uncomfortable about it. Now, is this a sexual advancement? So, the first problem is this: when an act becomes a case of sexual harassment. Now, there are different sensibilities of institutions, workplaces, because we have to keep in mind that this act applies to all sorts of workplaces. It applies to a law firm, it applies to Supreme Court, it applies to an Anganwadi worker, it applies to a primary school, it applies everywhere. But the sensibilities and the way it works are different. Maybe in a multinational company, a peck on a cheek will not turn a head. Because people will be very comfortable. Even they may say good morning to each other with a peck on a cheek. Now, that perhaps you may not find those same sensibilities in another workplace. So, sexual harassment is basically you're interacting. Earlier, there were mostly men who were coming to work. Now, there is women. So, they are interacting with each other and they are bound to be workplace conflict. Now, when it is a workplace conflict, when it is a issue relating to a human resource problem, when it is a grievance, when it is a employee-employee conflict, and when it is really sexual harassment, sometimes it's a gender bias, sometimes it's a stereotype, sometimes it's a problem of a glass ceiling. Now, what will you include and what will you exclude? We are still not very clear about it. Like, I'll give an example. For instance, the Ministry of Women and Child Development came out with a handbook in 2015, where they segregated the whole events in three parts. What constitutes sexual harassment, which means once you have one of these incidences, you need to go ahead with the inquiry. Then the second list was may or may not. And third, that they do not. Now, those do not were six things. So it says conditions of work, exercise of management right, dealing with unauthorized absences. It dealt with a constructive criticism about work and not the person. So all these things, taking disciplinary action, transfer of an employee from one place to the other. Now, these are not sexual harassment. These are not cases of sexual harassment. But the problem is that's a handbook. So, handbook, legally speaking, it's not a statutory, it's just a guide for people to implement that law. Delhi High Court recently said that accidental touching is not sexual harassment. So, this is just one aspect. Apart from that, there are several aspects which are confusing about how to conduct an inquiry, how do we do that. But the biggest problem is that we are still very confused. And what happens is that when we are confused, we all think from our own sensibilities. Suppose, I am a woman and I come to you and I say, this man is trying to touch me. I said, what has he done? He said, he's trying to shake hands with me. He said, it's a handshake. छू थोड़ी रहा है, हाथ ही तो मिला रहा है. So what are we doing? We are substituting our sensibility. So I am comfortable with a handshake. So अरे हाथ मिलाना कोई बड़ी बात नहीं होती है. Rather than going in that woman's position and understanding from her perspective that whether she is comfortable or she's not comfortable. And it's a very common mistake. Like I was doing a training session for the judges in a state, and I was referring to a Supreme Court judgment which said that we have to view it from the perspective of the person. So the judge sitting over there, he says, ऐसे कैसे? मैं अगर जज हूं तो मैं डिसाइड कर रहा हूं ना कि क्या सही है क्या गलत है. जो मेरे सामने कंप्लेंट लेकर आई है वो कैसे डिसाइड करेगी? नाउ सी somebody who is trained in law, and these were all senior judges, they were all at the rank of additional district judges, so they were not youngsters who had just been inducted. There were people who already had several years of training. But even for them to understand that the idea of a normal way we adjudicate a dispute is okay, somebody will say this, somebody will say that, and we'll decide which is right. In cases of gender sensitization, the problem is I have to put my sensibilities on a back burner and I have to get into the shoes of a person and then start my inquiry from there. Okay, if you are uncomfortable, is there a substance in why you are uncomfortable? I'm not going to question you why you are uncomfortable there. I may, of course, investigate and find out whether it is malicious. So, the biggest problem with gender sensitization, in my opinion, is this that we are absolutely confused about what is harassment, what is not harassment. And the moment we start discussing this, I am afraid that we haven't been able to come out with a module for somebody who does not have a training in law or for someone who's dealing with these issues for the first time can actually understand it in a layman's language and say, oh, I have understood. I can really now apply this system. So, jurisprudentially, I think there is a lot that needs to be done to describe and understand. And I'm sure, with time, it's right now the law is a skeleton. The courts will put some muscles into it. And as we go, someday we will be able to come out with more clarity on this issue.
Time and again, you have stated that you have gone paperless, and in your own words, you have become semi-technology equipped lawyer. But you are becoming one. You are trying to understand the technical advancements as well. But with the same technical advancements, and us being online, like currently we are recording this, and we are appearing on online courts. And there are so many things which have gone online. More than half of our lives is also online. All of these aspects which you talked about related to sexual harassment and the kind of sensitization that we need or that we already are doing, and you are enriching people with the kind of knowledge they need to, are we also doing the same thing for the online segment as well? Because there, not only this physical form of harassment comes in, there is a psychological form of harassment also comes into picture, which is unforeseen. And for some reason, there may be talks going on, I'm not saying that, but how are you addressing that? Because I'm really intrigued by the way you are talking about this as you chair all these kind of committees and you saying all this things online and in reality will make a lot of difference. So what all are we going to see? Are we going to really see the difference in between understanding how to work with this sensitized mind online as well, not only in the physical form, because harassment happens online as well.
That's true. In fact, it is for this reason that Rajasthan High Court recently, in a matter involving a bank employee, has said that the concept of workplace, because when we are looking at the entire sexual harassment, there are two laws on sexual harassment that we have on today. The one under the criminal procedure, which now, of course, is the BNS, Bharatiya Nyaya Sanhita, section 74 or 75, if I can recollect offhand. And the other is the one under the 2013 Act. Now, under the 2013 Act, it is akin to a disciplinary proceedings because that's where our law on sexual harassment is little different from the way it has developed in the West. In West, it is more in the concept of a tort law where there is a concept of a damage and a concept of compensation that comes in. Justice Verma in Vishakha said that sexual harassment is a misconduct as understood in service jurisprudence. So as a result, today what happens is that when we undertake a thing under the 2013 Act, then we are confining ourselves to a workplace where the employer has constituted a committee and he is taking something which is akin to a disciplinary action for a specialized misconduct. The other one, of course, is where you go to a police and you file an FIR and initiate a criminal proceedings. So far as this is concerned, one of the aspect is workplace, that if it has not happened within the workplace, because criminal matter with you don't have that kind of a problem. If it has happened, the jurisdiction of the police will come into play. Here, workplace is an issue. So one of the things which was there was something, I'm sitting at my home. You are sitting at your home. That's how we did our meetings in COVID. So whether we can apply this, the whole act, to an online meeting. So Jaipur bench of Rajasthan High Court in that matter said that all the concepts of this act would apply even to a virtual workplace. So now we are very clear on this. And although we do not have a very clear judgment from Supreme Court on this, but I really don't think so that we can in today's world take a different view. Even otherwise, before we had the Rajasthan High Court's judgment, there were other countries like Australia who had come out with these guidelines during COVID and said that these things would apply. There were a lot of companies who were on their own were issuing guidelines. I know a number of companies who have amended their sexual harassment policies and have made it clear that even the online thing, the emails, the WhatsApp groups, it all would apply to this. And there is no reason why it should not. So, one is this. The only problem is that in our country, again, we come back to the same problem. How do you sensitize people? How do you really tell them? Because whenever I have done these workshops, at least earlier, I noticed this. Now, of course, as I'm glad and I can say this, that gradually we see people are becoming more aware. But in the initial years, we could, and I'm sure this happens even now, but doesn't happen so frequently. And youngsters are really aware about it. But by and large, people always confuse sexual harassment with a sexual offense. So, to understand, because the word sexual is used in sexual harassment, they're always looking that we have not asked for any sexual favor. Oh, my intentions were all good. I didn't say anything. She's like my daughter, she's like my sister, or she's like my own family member. See, it's anyway difficult to sensitize people when it comes to the offline thing. In online, there is no physical contact. You and I are talking, right? So to think that I can harass you while sitting here in my office, while you're sitting in your office, it's something that's beyond comprehension to several people. So that's where sensitization comes into play, where you have to tell people that, look, I have come across people coming to me and saying, Ki, if there are so many do's and don'ts, how can we really work with our colleagues? We are supposed to be friendly with our colleagues. So, दोस्तों में तो ये होता है. Somebody will crack a joke. We can't have a straight up face all the time. So, why? My standard answer to them is that gender sensitization is only about understanding each other's sensibilities. How difficult it is for us. I may have different sensibilities than you have. Now, once you understand this basic principle, then it is not difficult to apply it to an offline or online mode. But to get to that is the most difficult thing. It's like one of those typical problems where so simple to be happy, but so difficult to be simple.
So true, ma'am. So true. And thank you for actually explaining all these aspects as well. Because in reality, people are unable to comprehend to this fact that there can be a sexual harassment that can happen even in online mode. But it is happening. And somehow I guess it will take time because it is just absolutely a new thing. Ma'am, now I'll be talking about this particular fact that how have you managed to balance your role as an advocate on record and as being a faculty member also at ISTM and Symbiosis Law School, and the kind of responsibilities that you have had as an individual, as being a daughter, as being a partner, as being your boss of your own law firm. It's too demanding, and as an individual, sometimes it's too stressful as well. And somehow, for some reason, I don't know why we do not talk about the kind of mental health or mental stress that lawyers especially go on. Because they listen to people, they listen to their problems as well, and they're facing their own problems. And I really feel like I'll get some or the other kind of better answer from your side as well, because you are balancing so many things in life. So, how are you doing that? And what will you suggest the youngsters who are entering this field, which is absolutely demanding?
The first and the foremost thing that I'll say is that you're very right. And I always say this, the most important thing to be a successful lawyer is to have a good mental health. It's an issue that we really don't talk about, we don't really address it. And particularly for us, see, imagine nobody walks in your office who is happy. People will come to you when they have some problem, and they will cry, they will sometimes scream, shout. Sometimes it involves their service, sometimes it involves work. And even when you are appearing for companies, so where I have represented employers, where I've represented companies, they also come with their own sense of stress. And usually, when you sign the wakalatnama, the idea is you take off all that headache. Now, to have so much going on, you have to retain the ability to laugh at the situation, to look something good and positive, to move on, and that is very difficult. Also, burning out is a big, big issue, which I have seen with number of my students which are facing, because some of my students have put in now in profession for 10 years, and I can see that burnout is for real. Now, that burnout happened for a number of reasons. See, first thing is, if you are skipping breakfast every day, if you are not eating, there is nothing going in. If you're not sleeping, you are not really rejuvenating. And you're not enjoying the work that you do. You're living in a toxic environment. So everything that contributes to it, it burns out. Now, I don't want to sound gender stereotypical person, so I'll put it like this. There have been research which has been done, and there is something known as, the scholars have called, the pipeline leakage of women in the profession. So you will generally see that a lot of women, young girls who will come, but between the age bracket of 35, 30, 45, you will see them all going away. Because also your career cycle is in conflict with your reproductive cycle. So that's also the time when you are trying to work hard in the profession. Is also a time when you are giving birth to a child, when you are trying to raise a child. And actually, birth is not so much a problem. The problem is once the baby is out. So then something keeps on coming. It's a full time job. So balancing, managing these things, it sometimes take a toll. And I am no superwoman, and I don't expect anybody around me to be a superwoman. So there are times when you will be exhausted. There are times when you will not be able to balance it. And on top of that, this is one profession, particularly if you're in litigation, we have usually long working hours. And there is also an emergency like situation all the time. Particularly if you are somebody who's practicing criminal law, your client has been arrested, or some property has been attached by the either somebody is demolishing a house. So it requires an immediate action, which means leaving everything behind and then taking up that job on hand. Of course, everybody suffers with you, then your family also then contributes their share of struggle. I am conscious of the fact that I can't take all the credit, because I am somebody who comes from a privileged section. So my first and foremost privilege was this, that I live with men who are gender neutral and perhaps more progressive than I can claim myself to be. So, this is my first privilege. So, if you are fighting a stereotype or a misogyny at home or around you or at workplace, it becomes a problem. It really becomes a problem. And unfortunately, whether the lawyers or the law firms are not in some Mars or Venus, they are very much on the same planet as we have other problems. So misogyny is a problem which exists across the workplaces. So if you are facing that problem, if you're facing that thing, it is likely to burn you. Now, enough of, these things may happen. What you can actually do is you can maintain your own sanity. Your sanity is in your hand. I think the most important thing that you need to do, which I tell all the youngsters, is please don't take yourself so seriously. It's a long profession. There is a long time. There is no need to do everything at 25. There is no need to do everything at 35. It's a long profession. You don't have a retirement age. So you can work on for as long as you are healthy. So the most important thing is that please pay attention to your health, mental and physical, and whatever works for you. Work some physical exercise works for you, that gives you strength. Go ahead. You want to read, go ahead for that. Watch a movie. I often ask the interns who come in my place, when was the last time you saw a movie? When was the last time you went out for a dinner? Have you gone and visited this place? And I sometimes feel they're too stressed out. They don't want to talk about it. They are like, no, no, we have to work. They're literally living in a pressure cooker kind of a situation. Like once I remember, this is associate of mine, and I always pull her leg for this incident. As soon as we got off from the court work, I had to pick my son from school. So I said, come along with me. We'll go, we'll eat something. So she then tells me that, no, no, ma'am, I have a lot of work to do. So she's my associate, but she's telling me, I've got a lot of work to do. I can't waste my time. I'm going back to office. I said, all right, good for you. You go back to work. I am not coming immediately. And just as it happened to another senior advocate, I had to meet her and she said, I'm having lunch. Why don't you come over? I said, may I? She said, yes, yes, come. So I just barged in and I had lunch and it was a fantastic lunch. So I came back and I told her, I said, see, look here, you refused to come with me because you had some work, and I went ahead, had the meeting also there, and had a good lunch. I'm cool. I had fun. I am relaxed. I'm ready to work ahead. And while you are just slogging there. So don't miss out on the opportunities to work and don't miss out on the opportunities to have fun. And in my case, and see, every individual is different. So I can only talk about myself. That's the beauty of human life, no human being is alike. So what may work for me may not work for you. And we all have different places. So when we talk about this balance of work life and professional life, we often forget that each one of us has a different point of balance. In my case, teaching. And so I typically take up classes once in a week. So once in a week, when I take those classes, it's like playing golf over a weekend. Or now that I'm pursuing my PhD, it helps me give a different perspective and it rejuvenates me to come back to court work and for the litigation, which in a way it means that yes, my diary is full. I enjoy everything that I do. I will not do it otherwise. So I have no grievances. So the idea is enjoy what you do and don't miss out on the opportunity of having fun. Laugh a bit. Read Henry Cecil if you can. I will very strongly recommend that. You will not take the court work also seriously then.
Thank you so much, ma'am, for such a candid interview and sharing the nitty-gritties and important aspects as well. It has been an enriching experience, and at Super Lawyers, we are very, very thankful for you to be here and for you to give us time. And it has been amazing interview. I know your
Thank you.
time is absolutely important, but thank you so much, ma'am. You still found time for
Thank you.
us.
I enjoyed talking and thank you so much. I don't know if I can be of any help to anyone in that sense. I am also trying to find out my own way every day. But thank you so much. I had fun chatting.